Global Operations. It is true that my son's company does indeed have a contract with Africa Global Operations for the provision of consultancy services. The said consultancy services are provided by my son's company to Africa Global Operations in a number of African countries other than South Africa. He informed me that South Africa was specifically excluded to avoid a potential conflict of interest. Since my reply in the National Assembly, I have sought to get more information regarding this matter. I have been subsequently informed that the payment referred to in the supplementary question by the Leader of the Opposition does not relate to that contract. I have been told that the payment to which the Leader of the Opposition referred was made on behalf of Mr. Gavin Watson into a trust account that was used to raise funds for a campaign established to support my candidature for the presidency of the African National Congress. The donation was made without my knowledge. I was not aware of the existence of the donation at the time that I answered the question in the National Assembly, close quote. In his response to the Public Protector's notice to him under Section 17 sub 9 of the PPA, the President explained the context of his original response and his follow-up letter. He said that the then National Campaign Manager of the CR17 campaign, Mr. Bejani Chauke, had told him in early September 2018 about rumours that his son, Andile Ramaphosa, Andile, had received a payment of 500,000 rand from AGO. This prompted the President to ask his son about the matter. Andile told the President that he had an arm's-length business relationship with AGO through his company Blue Crane Capital, Pty Limited. He had signed an advisory mandate with AGO in December 2017 and an anti-corruption and bribery policy in January 2018. The President said that Andile had shown him both of these documents. The President told the Public Protector that when Mr. Mkhwebane asked him about the payment to Andile of 500,000 rand, he assumed it concerned Andile's business relationship with AGO. It was on this basis that he gave his initial response to Mr. Mkhwebane in the National Assembly on the 6th of November 2018. However, after he had left the National Assembly on that day, one of his advisors, Ms. Donne Nicol, told him that the account that Mr. Mkhwebane had referred to, the EFG2 account, was an attorney's trust account that had been used by the CR17 campaign to raise funds. Ms. Nicol was on the fundraising committee of the CR17 campaign. The President was advised that the amount had not been paid to son Andile for work undertaken for AGO. In fact, the payment was a campaign donation from Mr. Watson. Armed with this information, the President says that he wrote to the National Assembly to set the record straight. The next heading is the complaints. On the 26th of November, Mr. Mkhwebane filed his complaint with the Public Protector. The main body of the complaint read as follows, quote, on the 6th of November 2018, during a question session in the National Assembly, I presented President Ramaphosa with the documentary proof of the payment and the sworn statement that alleges the money was intended for his son Andile. The President confirmed that he was aware of the payment, but had been satisfied that it was a lawful payment for services rendered by a consultancy firm owned or operated by Andile Ramaphosa. Subsequently, and on or about the 16th of November 2018, the President sent a letter to the Speaker of the National Assembly purporting to correct the answer he gave in the National Assembly 10 days earlier. In this letter of correction, the President reveals that the payment was actually a donation towards his campaign to be elected ANC President in December 2017. It is my concern that the set of facts related above reveal that there is possibly an improper relationship existing between the President and his family on the one side and the company African Global Operations, formerly Bosasa, on the other. The nature of the payment passing through several intermediaries does not accord with a straightforward donation and raises the suspicion of money laundering. The alleged donor is further widely reported to have received billions of rands in state tenders, often in irregular fashion. It is further my concern that the President may have lied to the National Assembly in his reply to my question on the 6th of November 2018. Close quote. Mr. Mkhwebane asked the Public Protector to investigate the complaint with utmost urgency. He said that another president could not be allowed to be captured and that the true facts of the matter needed to be established with all due haste. Mr. Shivambu's complaint was filed in January 2019. It was a complaint based on Section 4, subsection 1 of the Executive Code. He asked the Public Protector to investigate, A, whether, and I quote, whether the statement made by the President in the National Assembly on the 6th of November 2018 that he saw a contract between his son's company and African Global Operations is true and that a contract indeed does exist, and B, whether the President deliberately misled Parliament in violation of the Executive Ethics Code. Close quote. The next heading is the investigation by the Public Protector and the President's response. Having received the complaints, the Public Protector went about investigating them. She issued subpoenas to a number of individuals, including Mr. Watson, Mr. Fenter, Ms. Nicol, Mr. Chauke, Mr. Motlatsi, who was another organizing member of the CR17 campaign, Mr. Mkhwebane-Ramaphosa, and the law firm Edelstein, Faber and Mkhwebane Inc. Except for Andile, she interviewed all of these individuals. She also obtained affidavits from them, including from Andile. The Public Protector requested the FIC for their assistance in providing information on banking transactions. On receipt of information from the FIC, she subpoenaed Absa Bank and FNB Bank for bank statements from the accounts associated with the CR17 campaign. In addition, the Public Protector received responses from the President in respect of the complaints and in respect of her Section 7, subsection 9A notice to him. The President requested of the Public Protector that he be permitted to cross-examine Mr. Watson in terms of Section 7, subsection 9B of the PPA. It is common cause that the President was unable to do so before the Public Protector released her report. The parties differ on the reasons for this. The President also requested access to the FIC information provided to the Public Protector, but this was denied. It was evident from the Public Protector Section 7(9)A notice that she had extended the scope of her investigation to include not only the alleged misleading of the National Assembly by the President and the 500,000 rand payment to EFG2, but also the flow of funds for the entire CR17 campaign. She stated in her notice that her, quote, preliminary view, close quote, was that, quote, there is merit to the allegation relating to the suspicion of money laundering, close quote. In his response to the Section 7(9)A notice, the President contested the Public Protector's jurisdiction to investigate the CR17 campaign. He contended that her jurisdiction was limited to public administration and the improper exercise of public power. He asserted that the CR17 campaign fell outside of this ambit. As regards misleading Parliament, the President said he had not done so. He had answered the question put by Mr. Mkhwebane truthfully and in accordance with the information available to him at the time. The President denied that he had placed himself at risk of a conflict of interest between his official duties and his private interests. He also denied that he had used his position to enrich himself or his son through an association with AGO. He told the Public Protector that the 500,000 rand payment by Mr. Watson was a donation to the CR17 campaign and that he had been unaware of the donation at the time. He contended that he had no duty under the Executive Code to disclose campaign donations to the CR17 campaign. In support of this, the President gave the Public Protector a detailed account of the CR17 campaign. He made several important factual averments in this regard. The President's response included an outline of the governance and governance structures of the CR17 campaign. As to the role of the President and I quote, "The President was not involved in the management or operations of the campaign. He did not participate in organizing, communications, administration and security coordination of the campaign." Close quote. Further, quote, "The CR17 Management and Fundraising Committee decided that the President would not be directly involved in the solicitation of funds for the campaign." Close quote. And, quote, "The President was generally not aware of the donations except for his own donation as well as the contributions of James Motlatsi, Sifiso Dabengwa, and Donne Nicol." Close quote. The President explained that he had agreed with the CR17 campaign that those involved would not tell him about any of the donations they received from anybody. Quote, "It was probably not necessary for them to go that far, but it was a wise precaution. It precluded any suggestion that the President's goodwill can be bought." Close quotes. As to the donation of 500,000 by Mr. Watson, the President explained that it was Mr. Motlatsi who had approached Mr. Watson for a donation, as he, Mr. Motlatsi, knew Mr. Watson and did not discuss this with the President. Mr. Watson made the donation into the EFG2 account on the 18th of October 2017. The President was not made aware of this donation until after the President responded to Mr. Maimane's question on the 6th of November 2018. He told the Public Protector that he had no relationship with AGO nor with Mr. Watson. The President said that he had also made donations and loans to the CR17 campaign along with other ANC members and non-member supporters of the campaign. He explained the link between the bank accounts and entities that had been the subject of the Public Protector's investigation. EFG2 was the trust account established by the CR17 campaign at the law firm of Edelstein, Faber and Grobler Inc. Initially, donors made donations to the CR17 campaign into this account. A 2% commission was paid to Edelstein, Faber and Grobler Inc. on all amounts deposited by donors into the EFG2 account. The President submitted to the Public Protector in this regard that, quote, "Therefore, the large sums of money referred to by the Public Protector were perfectly lawful, did not breach any laws, were necessary for the overall running of the campaign, and the payments did not constitute maladministration. No monies went to the President or his family. The President, to the contrary, was one of the donors to the campaign." Close quote. The President also dealt with the Cyril Ramaphosa Foundation, the CRF, which the Public Protector had identified as one of the entities to have received payment for the CR17 campaign. In short, the President submitted to the Public Protector that he was not guilty of any of the complaints raised against him. He also called on the Public Protector to afford him a hearing in respect of any remedial action she may have been contemplating in her final report. The Public Protector interviewed Ms. Nicol, Mr. Motlatsi and Mr. Chauke. They confirmed the President's submissions regarding the CR17 campaign. She also told the Public Protector that donors, this is Ms. Nicol, told the Public Protector that donors were told as a precaution to donating that they should expect no favours in return. The next heading is the Public Protector's findings and remedial action. For purposes of her investigation and report, the Public Protector consolidated the two complaints. She identified the following issues as the focus of her investigation. We quote from her report. A. Whether on the 6th of November 2018, during question session in Parliament, President Ramaphosa deliberately misled the National Assembly and thereby acted in violation of the provisions of the Executive Ethics Code and the Code of Ethical Conduct and disclosure of members' interests for the National Assembly and Permanent Council members. B. Whether President Ramaphosa improperly and in violation of the provisions of the Executive Ethics Code and disclosure of members' interests for the National Assembly and Permanent Council members exposed himself to any situation involving the risk of a conflict between his official duties and his private interest, or used his position to enrich himself and his son through businesses owned by African Global Operations. C, whether there is an improper relationship between President Ramaphosa and his family on the one side and the company African Global Operations on the other side, due to the nature of the 500,000 rand payment passing through several intermediaries, instead of a straightforward donation to the CR17 campaign, thus raising the suspicion of money laundering, close quote. For the sake of simplicity, we refer to the issues identified under paragraph A as the, quote, misleading of Parliament issue, close quote, the issue identified under paragraph B as the, quote, disclosure issue, close quote, and the issue under paragraph C as the, quote, money laundering issue, close quote. It is necessary to set out in full the Public Protector's findings as regards each of these issues. In respect of the misleading of Parliament issue, the Public Protector made the following findings, and I quote, 7.1.1, the allegation that on the 6th of November 2018, during question session in Parliament, President Ramaphosa deliberately misled the National Assembly is substantiated. 7.1.2, President Ramaphosa's statement on the 6th of November 2018, in his reply to Mr. Mkhwebane's question, albeit defective in terms of the rules of the National Assembly, was misleading, as he also conceded in his correspondence to my office on 1st of February 2019, and even in his subsequent letter to the Speaker of the National Assembly on 14 November 2018, where he sought to correct the incorrect information he had provided in the National Assembly. 7.1.3. Consequently, President Ramaphosa's reply was in breach of the provisions of paragraph 2, subparagraph 3, subparagraph A of the Executive Ethics Code, the standard of which includes deliberate and inadvertent misleading of the legislature. He deliberately misled Parliament in that he should have allowed himself sufficient time to research on a well-informed response. 7.1.4, I therefore find President Ramaphosa's conduct, as referred to above, although ostensibly in good faith, to be inconsistent with his office as a member of Cabinet and therefore in violation of Section 96, subsection 1 of the Constitution as referred to above. As far as the disclosure, close quote, as far as the disclosure issue is concerned, she found as follows, open quote, 7.2.1. The allegation that President Ramaphosa, improperly and in violation of the provisions of the Executive Ethics Code and disclosure of members' interests for the National Assembly and permanent council members, exposed himself to any situation involving the risk of a conflict between his official responsibilities and his private interests, or used his position to enrich himself and his son through businesses owned by AGO, is substantiated. 7.2.2. In light of the evidence before me, it can be safely concluded that the campaign pledges towards the CR17 campaign were some form of sponsorship, and that they were direct financial sponsorship or assistance from non-party sources other than a family member or permanent companion, and were therefore benefits of a material nature to President Ramaphosa. 7.2.3, President Ramaphosa, as a presidential candidate for the ANC political party, received campaign contributions which benefited him in his personal capacity. He was therefore duty-bound to declare such financial benefit accruing to him from the campaign pledges. Failure to disclose the said material benefits, including a donation from AGO, constitutes a breach of the code. 7.2.4, I have evidence which indicates that some of the money collected through the CR17 campaign trust account was also transferred into the Cyril Ramaphosa Foundation account, from where it was also transferred to other beneficiaries. 7.2.5, President Ramaphosa, at the time of receipt of the donations, was the Deputy President of the Republic of South Africa and a Member of Parliament. He was therefore bound by the Code of Ethical Conduct and disclosure of members' interest for Assembly and Permanent Council members to declare such financial interest. 7.2.6. I therefore find President Ramaphosa's failure to disclose financial interest which accrued to him as a result of the donations received towards the CR17 campaign to be in violation of paragraph 2 of the Executive Ethics Code and accordingly amounts to conduct that is inconsistent with his office as Member of Cabinet as contemplated by Section 96 of the Constitution, close quote. Finally, concerning the money laundering issue, the Public Protector made the following findings. Again, we quote. 7.3.1. The allegation that there is an improper relationship between President Ramaphosa and his family on the one side and the company African Global Operations on the other side, due to the nature of the 500,000 rand payment passing through several intermediaries instead of a straight donation towards the CR17 campaign, thus raising suspicion of money laundering, has merit. 7.3.2. I have taken into account of the facts as well as prima facie evidence before me. I am therefore of the view that there is merit to the allegation relating to the suspicion of money laundering as alluded to in the complaint lodged with my office. 7.3.3. However, I have decided to refer this matter to the relevant institution for further probing as provided for in Section 6, subsection 4C, Roman 1 of the Public Protector Act, which states that the Public Protector may, quote, at any time prior to, during or after an investigation, if he or she is of the opinion that the facts disclose a commission of an offence by any person, bring the matter to the notice of the relevant authority charged with prosecutions, close quote. The Public Protector also made certain observations regarding proceedings in the National Assembly. She observed that some members of the House did not give sufficient prior consideration to questions or to the responses they are to provide. She also observed that the rules of the National Assembly were silent on whether members are permitted to make subsequent written submissions to correct or clarify the oral replies they have given. The Public Protector directed the Speaker to take the following remedial action to remedy the improprieties she had identified. Quote, 8.1.1. Within 30 working days of receipt of this report, refer His Excellency President Ramaphosa's violation of the Code of Ethical Conduct and disclosure of members' interests for Assembly and Permanent Council members to the Joint Committee on Ethics and Members' Interests for consideration in terms of the provisions of paragraph 10 of the Code. 8.1.2. Within 30 working days of receipt of this report, consider within her discretion for deliberations by members of Parliament in terms of the rules of the National Assembly, issues relating to my observations under paragraphs 6.1 to 6.6 of this report for possible review and amendment thereof. 8.1.3. Within 30 working days of receipt of this report, demand publication of all donations received by President Ramaphosa, because as he was the then Deputy President, he is bound to declare such financial interests into the members' registrable interests register in the spirit of accountability and transparency, close quote. The NBDPP was directed to, quote, 8.2.1, within 30 working days of receipt of this report, take note of the observations contained in paragraph 7.3.1, as well as the recommendations contained in paragraph 7.3.3 of this report, and in line with section 8, subsection 4C, Roman 1 of the Public Protector Act, conduct further investigation into the prima facie evidence of money laundering as uncovered during my investigation and deal with it accordingly, close quote. The Public Protector went further by directing particular monitoring mechanisms to be effected. In this regard, in paragraph 9.3 of the report, she directed both the Speaker and the NDPP to, quote, within 30 working days of the issuing of this report, provide the Public Protector with the implementation plan indicating how the remedial action referred to in paragraphs 8.1.1, 8.1.2, and 8.1.3 of the report will be implemented. In paragraph 9.4, she directed the NDPP to, quote, within 30 days from the date of the issuing of this report, and for approval of the Public Protector, submit an implementation plan to the Public Protector indicating how the remedial action referred to in paragraph 8.2.1 of this report will be implemented, close quote. The next heading is grounds of review. It is common cause that, based on the decision of the Supreme Court of Appeal in Minister of Home Affairs versus Public Protector, the Public Protector's reports do not constitute administrative action. Accordingly, as they constitute an exercise of public power, they are reviewable under the principles of the rule of law in terms of Section 1C of the Constitution. The President seeks an order reviewing, declaring invalid and setting aside the Public Protector's decision to investigate and report on the CR17 election campaign for the ANC leadership elected in December 2017, the Public Protector's report, the findings and remedial orders in paragraphs 7.1, 7.2, 8.1.1, 8.1.3, 8.2.1, 9.1, 9.3 and 9.4 of the report. The Speaker seeks to review and set aside the remedial and monitoring measures insofar as they are directed at her. She contends that these orders are inappropriate and unlawful in that they impermissibly trench on the constitutional discretionary power of the National Assembly to hold the executive to account. The NDPP seeks to review and set aside the remedial and monitoring orders insofar as they are directed at her. In particular, the NDPP contends that the remedial and monitoring actions are unlawful and irrational. The President, the Speaker, and the NDPP seek orders of costs against the Public Protector in the event that their review applications succeed. The President seeks a punitive costs order against the Public Protector, that is, an order directing her office to pay costs on an attorney and client scale. However, the President does not seek a personal costs order against the Public Protector. The Public Protector and the EFF oppose the relief sought by the President, the Speaker, and the NDPP. The next heading is Amabongane's application. Before dealing with the main issues before us, it's necessary to contextualize Amabongane's application. It brings a conditional constitutional challenge to the Executive Code. The constitutional challenge relates to the duty of members of the Executive to disclose donations made to campaigns for positions within political parties. Next heading is the issues. The issues we must determine are as follows. The first issue is whether the finding of the Public Protector that the President had misled Parliament in violation of the Executive Code was rational and lawful. The second issue is whether the Public Protector had jurisdiction to investigate donations to the CR17 campaign at all. The jurisdictional question primarily underpins the disclosure issue. If the Public Protector did not have jurisdiction to investigate the CR17 campaign donations, then her finding that the President breached his duty of disclosure by not disclosing CR17 donations is for this reason alone open to being reviewed and set aside. The third issue is whether, even if the Public Protector had jurisdiction to investigate the CR17 campaign donations, her conclusion that he was obliged to disclose the donations was lawful and rational. The fourth issue is whether the finding by the Public Protector that there was merit in the complaint of a suspicion of money laundering was rational and lawful. The fifth issue is whether the Public Protector's report and findings are subject to review on the basis that she failed to afford the President audi alteram partem before finalising her findings. The sixth issue is whether the remedial and monitoring orders directed at the Speaker and the NDPP are lawful. Of course, if we determine that the findings underpinning the remedial and monitoring measures should be reviewed and set aside, it would follow as a matter of course that the remedial and monitoring measures associated with them should suffer the same fate. However, the challenges to the remedial and monitoring measures ordered by the Public Protector raise important issues concerning the ambit of her powers. For this reason, our view is that we should consider these issues regardless of the outcome of our determination on the Public Protector's substantive findings. The seventh issue is the Amabungane application, which is conditional on our findings regarding the disclosure issue. And finally, we must consider the question of costs.
The next heading is the finding that the President misled Parliament. There are some fundamental difficulties with the Public Protector's finding that the President misled Parliament. To begin with, it is apparent from the report that the Public Protector was confused about the legal foundation of her finding. It is common cause that the finding was based on the Executive Code. The relevant paragraph of this code is 2.3 sub A. It prescribes that, I quote, members of the executive may not willfully mislead the legislature to which they are accountable, close quotation mark. For some inexplicable reason, the Public Protector reframed the paragraph and the test. In paragraph 5.1.28 of her report, she purports to quote from paragraph 2.3a when she says the following, I quote, regard must be had to section 2.3 of the code, which states that members may not deliberately or inadvertently mislead the President or the Premier, or, as in this case, the legislature, close quotation. Of course, this cannot have been a direct quote from paragraph 2.3a, as indicated by the Public Protector's inclusion of the phrase, open quote, or, as in this case, close quote. However, her purported excerpt from the quote is even more fundamentally problematic than this. The Public Protector replaces willfully with deliberately or inadvertently. This error and confusion are repeated throughout the report. It occurs in her final finding, where she concludes that, I quote, consequently, President Ramaphosa's reply was in breach of the provisions of paragraph 2.3a of the Executive Ethics Code, the standard of which includes deliberate and inadvertent misleading of the legislature. He inadvertently and or deliberately misled Parliament in that he should have allowed himself sufficient time to consider the question and make well-informed response, close quote. In our view, the President is correct in his submission that the Public Protector's confusion permeates her entire consideration of this issue. Her confusion is borne out by her ultimate conclusion, which is difficult to understand. Counsel for the President submitted that it was garbled. At best, we can understand. The Public Protector appears to have found that the President misled Parliament either deliberately or inadvertently by answering Mr. Mkhwebane's question on the spot and not allowing himself time to go away and consider the question so that he could make a well-informed response. At best, this conclusion seems to point to carelessness on the President's part, or, with the benefit of hindsight, an ill-judged decision to answer Mr. Mkhwebane's question then and there. However, by no stretch of law, logic, or even ethics could conduct of this nature be said to amount to a willful or deliberate misleading of Parliament, such as to amount to a violation of paragraph 2.3a of the Executive Code. In her treatment of this issue, the Public Protector demonstrated a fundamentally flawed approach to the principles underpinning the question of whether the President violated the Executive Code by willfully misleading Parliament. It is to be expected of the public protector to proceed from the premise of the correct formulation of paragraph 2.3a to understand what the test is that must be applied to determine whether there has been a violation, and finally, to pronounce a conclusion that can be clearly understood and is in line with that test. Unfortunately, the public protector's approach to this issue, in this case, falls far short of this. In this regard, the public protector's finding on the misleading of Parliament issue is fatally flawed due to a material error of law. For this reason alone, the finding warrants review and setting aside. However, there are further reasons for reaching the same conclusion. If one considers the facts before the public protector, it is clear that they simply did not establish that the President willfully misled Parliament at all. The factual premise of Mr. Maimane's question was that he, Mr. Maimane, had proof that Mr. Watson, the CEO of AGO, had caused a payment of 500,000 to be made to the President's son. This was the statement of fact that was put to the President. He was then asked to set the record straight as, quotation mark, "We cannot have family members benefiting," close the quote. It is so that Mr. Maimane mentioned the amount, the account name, and the date of the transfer in his question. However, it is also clear that his real concern was that the President's son had secured an improper benefit. Mr. Maimane asked the President to explain the payment to his son. It is important to appreciate that the President was not asked by Mr. Maimane to comment on whether the account EFG2 was in fact an account held by Andile, nor was he asked to confirm that the payment on that date was one made to his son. These were given facts that Mr. Maimane put to him as having already been established, and the President's answer was directed at those facts. Of course, we know with hindsight that the payment was not to Andile and that the account EFG2 was not linked to him. At the time, however, these facts were not known to either Mr. Maimane or the President. There is no evidence to indicate that the President knew about the EFG2 account at the time he answered the question, or about the 500,000 donation made by Mr. Watson to his CR17 campaign. The uncontested evidence before the public protector was that the President only found out about the donation and about the EFG2 account after he had answered the question in Parliament. In this context, it is difficult to understand how the President's answer could rationally be viewed as anything but honest and reasonable, given the nature of Mr. Maimane's question. There was no evidence before the public protector to gainsay the President's version, which was backed up by the evidence of Mr. Mkhwebane, Mr. Chauke, and Ms. Nicole. He said that he had spoken to his son about his connection with AGO in the previous months, and that this was why he had assumed that the payment Mr. Maimane mentioned in his question as having been made to his son was a payment for services his son had rendered to AGO in terms of this agreement with it. The facts simply do not point to the President having acted so as to willfully mislead when he answered Mr. Maimane's question. The evidence supports his version that he acted in good faith. Indeed, the public protector accepted the President's good faith in this regard in her Section 7, Sub 9 notice and in parts of her report. In her Section 7, Sub 9 notice, she concluded that, I quote, "His conduct referred to above, although in good faith, is inconsistent with his office as a member of Cabinet and therefore in violation of Section 96, Sub 1 of the Constitution," close the quote. This is repeated by the public protector in the executive summary of her report, although she also states in her conclusion in the report that the President acted ostensibly in good faith. Whatever the explanation of this contradiction might be, the public protector is on record as having accepted the President's bona fides in this regard. Far from indicating an attempt to mislead the National Assembly, this was conduct consistent with an intention to ensure that Parliament is given the correct information, rather an intention willfully to mislead it. What is more troubling is that the President dealt with the public protector's acceptance of his bona fides when he responded to her Section 7, subparagraph 9A notice. His response recorded that, I quote, "The public protector has correctly found that the President acted in good faith. That should be the end of the matter. Any suggestion that the President contravened the Executive Ethics Code is incompatible with the public protector's own finding that his response to Mr. Mkhwebane was given honestly and in good faith," close quote. In her response, in her final report, the public protector referred to this submission as, open quotation, preposterous, close the quote. This response displays a deep-seated inability or refusal to process facts before her in a logical and fair-minded manner. Such a response is difficult to reconcile with her constitutional obligations. Furthermore, it was totally irrational for the public protector to make a finding that the President misled Parliament on the basis that he should not have answered Mr. Mkhwebane's question before first checking the facts. The President had sufficiently clarified how it came about that he had answered Mr. Mkhwebane's question on the spot. In its submissions to us, the EFF suggested that the public protector had been correct in her finding on this issue. The EFF contended that the court should apply what it called a hybrid test for determining whether the President misled Parliament in breach of the Executive Code. As we understand the contention, it is that the President was under the highest ethical duty as the head of state to account properly to the National Assembly. For this reason, so the submission went, his conduct in answering Mr. Mkhwebane's question must be judged on ethical standards and not solely on the legal standard of whether he intentionally misled Parliament. According to the EFF, the President breached his ethical standard when he told the National Assembly that he was telling the truth based on facts he had gathered from his son. The EFF says that hindsight shows that what the President claimed to be truth was not the truth. The EFF submits that this explains the public protector's finding that he misled Parliament by not taking time to answer the question properly. Had he done so, he would have provided Parliament with the truth. These submissions have no substance. We are not told which rule of Parliament is the source of the contended highest ethical standard. In addition, the EFF's submissions come nowhere to showing the requisite willfulness to found substance in the complaint investigated by the public protector. The EFF further contends that the President's answer to Mr. Mkhwebane must be considered in conjunction with his prior conduct in what the EFF says was his deliberately distancing himself from the donations made to the CR17 campaign. The undisputed evidence of the President is that the reason why it was decided that he should be insulated from information about donations to the CR17 campaign was precisely to avoid him being placed in a position of possible conflict of interest. His uncontested version is that his insulation from the details of the financial transactions and donors to the CR17 campaign ensured that he avoided the risk that donors might subsequently expect some form of payback from him. There is no evidence to the contrary, nor is it an implausible explanation. On the contrary, it seems to have been a reasonable strategy to employ in order to avoid possible conflicts of interest. Finally, it is necessary to deal with an important anomaly in that report. Although the public protector decided to consolidate the two complaints, she made no findings in respect of the complaint of Mr. Shivambu. The public protector included the agreement and anti-corruption policy between AGO and Andile in her report. Accordingly, they clearly existed. However, she did not draw the obvious conclusion from this evidence, namely that the President had not misled Parliament in this respect. She does not explain her omission. In all fairness, the President was entitled to be exonerated on this complaint. Instead, the public protector ignores the point of Mr. Shivambu's complaint, which was to question whether the President misled the National Assembly about his son's contract. The public protector did not make the obvious finding that the President had told the truth about his son having an agreement with AGO. In our view, in failing to do so, the public protector did not act with an open mind and so breached one of the cardinal requirements of her position. For these reasons, we find that not only did the public protector commit a material misdirection in her legal approach to the misleading of Parliament issue, but she also reached an irrational and unlawful conclusion on the facts that were before her. Further, she did not approach the issue with an open mind. The President's review of her finding in this regard, therefore, must be upheld and the findings set aside. The next heading: did the public protector have jurisdiction to investigate the CR17 campaign donations? The public protector's findings on the disclosure issue and on the money laundering issue arose out of her investigation into the flow of funds to and from the CR17 campaign. She subpoenaed bank records linked to the identified account and analyzed the flow of funds. From this, she concluded that the President had opened himself up to a risk of a conflict of interest between his personal and official obligations. She also concluded that a prima facie suspicion of money laundering was established. Her investigation into the CR17 campaign bank records was essential to her eventual findings. In his complaint, Mr. Mkhwebane raised a concern that the payment from Mr. Watson might be indicative of an improper relationship existing between the President and his family on one side and the company African Global Operations on the other. On the question of money laundering, he again focused on the payment from Mr. Watson, saying that the nature of the payment passing through several intermediaries does not accord with a straightforward donation and raises suspicion of money laundering. He raised a concern about state capture, saying that, I quote, "We cannot allow another president to be thus captured," close the quote. This was in the context, as stated by Mr. Mkhwebane, of AGO having been reported as having received billions of rands in state tenders in an irregular fashion. Mr. Mkhwebane's complaint was not about the CR17 campaign. Mr. Shivambu's complaint similarly had nothing to do with the CR17 campaign. It also focused on the payment of 500,000 by Mr. Watson. However, it was even more specific. It requested the public protector to investigate whether there was an existing contract between AGO and the President's son, as the President had claimed, and whether the President had indeed seen the contract. The President contends that the public protector acted outside of the ambit of her powers by nonetheless proceeding to investigate the CR17 campaign and by making findings flowing from her investigation. According to him, the CR17 campaign was a campaign that took place within the context of an election campaign internal to the ANC. It was for the election of the president as president of the ANC and for the election of other like-minded members to additional positions within the party structures. The funding that the public protector investigated was private funding. It was sourced from private donors who supported the campaign. Neither public affairs nor public funds were involved in the campaign. Thus, the President says that the public protector had no jurisdiction to investigate the CR17 campaign and its donations. The public protector disputes this. She says that her powers are wide enough to encompass her investigation into the CR17 campaign and that she acted within her jurisdiction in doing so. There can be no doubt that the public protector has wide powers. This fact has been repeated in numerous dicta, including those emanating from our highest court. However, like any statutory body, those powers are not unlimited, nor is the public protector's sphere of jurisdiction unlimited. The question is, what were the limits of her jurisdiction in this matter? This is not an abstract question. It must be answered by looking at, among other things, the context in which the public protector investigated the CR17 campaign, the powers she relied on in doing so, the facts she had before her, and the particular findings she made in her report arising out of her investigation. The source of the public protector's powers lies in Section 182 of the Constitution. The Public Protector Act set out her additional powers and functions. Finally, the Public Protector has powers to investigate under Section 3, subsection 1 of the Ethics Act. Altogether, this provision circumscribes the conduct that the Public Protector is competent to investigate. The overriding feature of Section 182, sub 1 of the Constitution and Section 6, subsection 4 of the Public Protector Act is that her sphere of competence or jurisdiction is limited to matters involving state affairs, public administration, the exercise of public powers or functions, public funds, or conduct occurring in or concerning the affairs of any of the spheres of government. It is implicit in this circumscription of her powers that she cannot investigate matters falling within private sphere. From inception, the President disputed the Public Protector's competence to investigate the CR17 campaign. His attorney expressed as much in the covering letter accompanying the President's response to the Public Protector's Section 7, sub 9A notice. The President's stance was echoed in his representation attached to the letter. In her report, the Public Protector stated that, I quote, "The conduct of President Ramaphosa amounts to conduct in state affairs, and therefore the matter falls within the ambit of the Public Protector's mandate," close quote. The Public Protector's report and answering affidavit identify the basis on which she claimed to have jurisdiction to investigate the CR17 campaign. She relied on her constitutional powers under Section 182, sub 1, her further powers under the Public Protector Act, and in particular on Section 6, sub 4 and 7, her duty to investigate complaints under the Ethics Act, and on the nature of the complaints lodged. Her stance may be summarized as follows. Section 182 of the Constitution gives her the power to investigate any conduct, not merely any complaint. She has the power to determine from a complaint what conduct should be investigated. Section 6, subparagraph 7 further extends her powers by permitting her to investigate issues on her own initiative. If these are issues she has the power to investigate under Section 6, subsection 4 or 5. Further, she received 2 complaints under the Ethics Act. Mr. Mkhwebane's complaint included a concern about money laundering in relation to the payment by Mr. Watson. According to the public protector, she could not ignore her duty to investigate this issue. Consequently, she obtained a bank statement associated with the CR17 campaign and investigated them. She was, open quote, further concerned that these sums of money claimed to be donations created a situation of the risk of some sort of state capture by those donating such large sums of money, close quote. She was also concerned about the manner in which the transactions were concluded in light of the complaint of money laundering by Mr. Mkhwebane. As the donations were made at the time when the President was the Deputy President of the Republic, the public protector held the view that he may have opened himself to a risk of a conflict of interest under Section 96 of the Constitution. For clarity, Section 96 of the Constitution deals with the conduct of cabinet members and deputy ministers. Subsection 2b provides that they, I quote, may not act in any manner that is inconsistent with their office or expose themselves to any situation involving the risk of a conflict between their official responsibilities and their private interests. Of course, the public protector enjoys wide powers, including the power to investigate any issue on her own initiative. However, she only enjoys these powers within her sphere of competence. She cannot use her wide powers as a basis to extend her jurisdiction. On the contrary, the limits of her jurisdiction set the outer limits of her powers. Thus, she cannot initiate her own investigations on an issue if the issue falls outside her sphere of competence, nor can she investigate a complaint that falls outside it. Critical to her sphere of competence, as we pointed out earlier, is that she may only investigate improper or allegedly improper conduct in state affairs or in the public administration in any sphere of government. This raises the question, what is the meaning of state affairs? We were urged during oral argument by Counsel for the Public Protector to adopt a very broad definition of state affairs based on the concept of the state in political science. Counsel urged us to steer clear of restrictive, lawyering meanings of the concept. In what was admittedly his own gloss, he submitted that anything associated with the population, the territory, the sovereignty, or the government of the state falls within the meaning of state affairs. Extrapolating from this, Counsel submitted that any conduct involving the Deputy President of the country in his quest to become a leader of his party and consequently to become President of the country is a matter of state affair. On this basis, he submitted that the
of the SCA
the city
says that section so subject to
constantly that refugees has a place to go back to. In other words, if they were removed, if they do leave the church, they will have an address to go to. Our mayor had discussions with various groups who confirmed this, and the groups welcomed them back into the group. In other words, there will be no homelessness. It is correct that paragraph 4.4 was included in the court order. Apologies. So the reason for that was
responsibilities and his private interest, contrary to the Ethics Act and the Executive Code. Alternatively, there was substance in the allegation that the President used his position to enrich himself and his son through AGO. She found that on the evidence before her, it could be concluded that the donations to the CR17 campaign were a direct financial sponsorship of the President and therefore constituted benefits of a material nature to him. She found that the President received campaign contributions which benefited him in his personal capacity. Accordingly, he was duty-bound to declare them. The President contends that these elements of her findings are not supported by the evidence that was before her. For this reason, they are irrational and unlawful. Further, that on the undisputed facts and on a proper interpretation of the Code, the President did not have a duty to disclose under the Ethics Code. For this reason, too, he contends that her findings are unlawful. There is some overlap between the issues for consideration here and those that arose under jurisdiction question. In particular, the misdirected conflation that the public protector made of the activities of the CR17 campaign and the President permeate her findings here too. In this conflation, she ignored the uncontested evidence before her. We have already explained that on the facts before her, the CR17 campaign was much broader than simply supporting the President as prospective President of the ANC. Further, the evidence established that he was not involved in the organizational structures of the campaign and generally not in the fundraising. To the extent that the President was involved in the CR17 campaign, it was as a member of the ANC. He was entitled to engage in the activities of the CR17 campaign in furtherance of his rights under Section 19, subsection 1 of the Constitution. There was nothing untoward in this. There was also no evidence at all before the public protector concerning anything the President did that involved the exercise of his official duties overlapping with his involvement in the CR17 campaign. There is thus no evidence that in his involvement in the CR17 campaign, he placed himself at the risk of a conflict between his official responsibilities and his private affairs. There was also nothing to substantiate her finding that there was merit in the allegation that he used his position to enrich himself and his son through AGO. The public protector's finding that the President received direct financial sponsorship through the CR17 campaign was based on her conflation of that campaign with the President. The public protector has not identified any evidence nor facts to substantiate her conclusion that he received direct personal sponsorship through the campaign. The same goes for her finding that he received campaign contributions through the CR17 campaign that benefited him in his personal capacity. This conclusion again emanated from her conflation between the CR17 campaign and the President. There was simply no evidence that the President received personal financial benefit from any campaign contributions. The question that arises is, if the President did not personally benefit or receive financial campaign contribution through the CR17 campaign, as the public protector found, how could the public protector rationally conclude that he was obliged under the Executive Code to make the disclosure of the donations? The source of the duty of members of the Executive to make disclosure of their financial interest is Section 96, subsection 1 of the Constitution and the Ethics Act. I quote, Section 2, sub 2b, Roman figure 3 provides that the Code of Ethics must include provisions prohibiting such members from exposing themselves to any situation involving the risk of a conflict between their official responsibilities and their private interest. Close the code. Paragraph 6 of the code set out the financial interest that must be disclosed. This includes 1. Under paragraph 6.2, direct financial sponsorship or assistance from any source other than the member's party, which benefits the member in her personal and private capacity. And under paragraph 6.4, the nature and source of any other benefit of a material nature and the value of that benefit. We stated above that on the facts before the public protector, there was nothing to substantiate her conclusion that the President was obliged to disclose donations made to the CR17 campaign under paragraph 6.2 of the Code. This is because there was no evidence that he received direct financial sponsorship from the donations through the CR17 campaign. It was submitted to us in oral argument on behalf of the EFF that because the President indirectly benefited from the CR17 campaign, this attracted an obligation under the Executive Code to disclose the donations received by the CR17 campaign. One fundamental difficulty with this proposition is that it is not the basis on which the public protector reached her conclusion. We are required to determine the rationality of her conclusions and the reasons for those conclusions. Her conclusions, as we have already noted, were founded on her conflation between the CR17 campaign and the President. It was on this basis that she assumed that what accrued to the CR17 campaign accrued to the President for his personal benefit and were thus disclosable benefits. Therefore, the submission by the EFF does not assist the public protector. Apart from this, paragraph 6.4 does not describe the kind of indirect benefit that must be disclosed. What the President gained from the CR17 campaign was support for his candidature as ANC President. So did other members of the party whose candidatures were supported by the campaign. The nature of the benefit was to advance the internal party political power base of those candidates. It was not a financial benefit upon which one could place the type of value required to be disclosed under paragraph 6. It would be irrational to equate the value of this indirect political benefit with the value of all donations received by the whole CR17 campaign, and to find that the President was under an obligation to disclose those donations. For this reason, the President was not obliged to make disclosure of donations received by the CR17 campaign under paragraph 6.4 of the Executive Code. We must also mention a further submission by the EFF on this issue, making common cause with the public protector. The submission is that in directly receiving the benefit emanating from the CR campaign, the President placed himself in a position where he exposed himself to a situation involving the risk of a conflict between his official responsibilities and his private interest. For this, it was argued on behalf of the EFF, the President was obliged to disclose the CR17 donations, and his failure to do so violated Section 96, sub 2 of the Constitution. Clearly, this submission must be pegged to paragraph 6.2 of the Code to resonate with what the public protector found. The EFF argued that this conclusion was upheld by this court in President of the Republic of South Africa against Public Protector and others, the Zuma case, where the then President's power to appoint the chairperson of a commission of inquiry was curtailed on the basis, so it was submitted, that the then president's private interest may have improperly affected how he discharged the powers of his office. The submission was that should we uphold the president's argument in the case before us, that would amount to a declaration that the Zuma case was decided on an incorrect basis. This argument is contrived. It ignores the cardinal issues in the Zuma case and one before us. The Zuma case had nothing to do with the duty of disclosure, but with a finding of alleged malfeasance by the then president in allegedly allowing his private interest and his family to influence how he exercised his powers in state affairs. Example, as regards the appointment of ministers. There can therefore be no question of it in the case before us, of the Zuma case having been decided on an incorrect basis. We conclude that the findings of the public protector on the disclosure issue are unsustainable. Rational findings must be premised on a proper factual and legal foundation. That foundation was lacking in this case. The public protector's conclusion that the president breached the executive code by failing to disclose donations to the CR campaign was irrational and unlawful and false to be set aside. The next heading, the findings of prima facie suspicion of money laundering. In her report, the public protector made the very serious finding that a prima facie suspicion of money laundering had been established. She framed the question of money laundering that was before her as follows, I quote, whether there is an improper relationship between President Ramaphosa and his family on the one side and the company African Global Operations on the other side due to the nature of the 500,000 payment passing through several intermediaries instead of a straightforward donation to the CR17 campaign, close quotation mark. The focus of the money laundering issue was thus the payment by Mr. Watson. This is consistent with Mr. Mkhwebane's complaint, which introduced the issue of money laundering. However, in her investigation of the matter, the public protector extended her investigation on the money laundering issue beyond the single payment from Mr. Watson. Having subpoenaed the CR17 campaign bank statements, she proceeded to analyze them. She concluded from this, I quote, I wish to express my preliminary view that such a scenario, when looked at carefully, creates a situation of the risk of some sort of state capture by those donating these monies to the campaign, close quotation mark. The public protector went further to identify the legal prescripts upon which she would draw her conclusion on the issue of money laundering. She referred to the Prevention and Combating of Corrupt Activities Act, PRECA, and noted that Section 3 of that Act provides for, among others, an all-encompassing general offense of corruption. She stated in this regard, I quote, in terms of this section, anybody who accepts any gratification from anybody else or gives or even agrees to give or offers to give any gratification from anybody else or gives any gratification to anybody else to influence the receiver to conduct himself or herself in a way which amounts to the unlawful exercise of any duties commits the act of corruption. Close quotation. She concluded that the evidence established a prima facie suspicion of money laundering based on PRECA. She reached this conclusion despite the fact that PRECA does not deal with money laundering. She stated, I quote, my investigation into the issue pertaining to possible money laundering is premised on the above legislation dealing with corruption and applies not only to private individuals who offer bribes, but also to private individuals who accept bribes, close quotation. It is necessary to unpack the public protector's findings leading to her conclusions. The question she framed at the outset contemplated the president, his family, AGO, and the 500,000 rand payment. The issue was whether there was an improper relationship between the president's family and AGO. She then makes the statement that the 500,000 rand passed through several intermediaries. The evidence is that the money went from Watson's personal account into the account of Myoto Trading, which was associated with Mr. Watson. The evidence is that both accounts had nothing to do with the president. From the Myoto account, the money was deposited into the EFG2 account, being the CR17 campaign bank account. What this illustrates is that only one account is involved on the CR17 campaign side as far as this amount is concerned. There is no evidence of several intermediaries as stated by the public protector. We also point out that the paucity of evidence of the so-called several intermediaries points to the public protector simply repeating the language used by Mr. Maimane in his complaint to her office. What the evidence shows is that there was one straightforward transaction into the EFG2 account when it left the Watson side. To state the obvious, the question framed by the public protector to investigate possible money laundering was not based on the evidence at her disposal. In fact, it was not based on any evidence at all. The public protector then widened her investigation beyond the 500,000 rand specifically mentioned in the Maimane complaint. She focused on the other transactions involving the CR17 campaign and expressed the open quote preliminary view that the scenario presented a risk of some state capture by those donating to the CR17 campaign, close quotation mark. We know that the public protector did not have facts or evidence that the donors were either public officials or that public funds were used to donate to the CR17 campaign. In fact, the evidence she had at her disposal identified the donors as private donors. It is inexplicable how then the public protector made the state capture statement. To buttress her view that the public protector then referred to PRECA to found her conclusion that money laundering was involved. She made the firm finding that based on PRECA, the evidence at her disposal established a prima facie suspicion of money laundering. We know that she had no evidence, even remotely, suggesting that money laundering was at play. We also know that PRECA has nothing to do with money laundering. The legislation that established the offense of money laundering is the Prevention of Organized Crime Act, called POCA, and particularly Section 4, 5, and 6. First, a person who knows or ought reasonably to have known that property is or form part of the proceeds of unlawful activities commits an offense in terms of Section 4 if he enters into any agreement, arrangement, or transaction in connection with the property or perform any other act in connection with the property which has the effect or is likely to have the effect, one, of concealing or disguising the nature, source, location, disposition, or movement of the property, or the ownership of the property, or any interest in the property. Two, of establishing or assisting any person who committed an offense to avoid prosecution or to remove or diminish any property acquired as a result of an offense. Second, a person commits an offense in terms of Section 5 if he knows or ought reasonably to have known that another person has obtained the proceeds of unlawful activities and enters into any transaction, agreement, or arrangement in terms of which one, the retention or control by or on behalf of that other person of the proceeds of unlawful activity is facilitated, or the proceeds are used to make funds available to that person to acquire property on his behalf or to benefit him in any other way. Third, a person who acquires, uses, or possesses property and who knows or ought reasonably to have known that it is or form part of the proceeds of unlawful activities of another person commits an offense under Section 6. The essence of the offense is the concealment of proceeds of crime. Unless the money involved in the suspected money laundering transaction is the proceeds of crime, it does not matter how many accounts and transactions are involved in dealing with the money. There can be no offense of money laundering without the proceeds of crime. The other legislation that deals with money laundering is the Financial Intelligence Center Act, the so-called FIC Act. The Act was introduced to combat money laundering activities and the financing of terrorist-related activities. There was no evidence before the public protector that any of the donations made to the CR17 campaign were the proceeds of crime, nor that the president entered into an agreement or an arrangement whereby he assisted Mr. Watson to conceal or disguise money, which he knew or ought reasonably to have known is the proceeds of crime. There was, further, no evidence before the public protector that the president knew or ought reasonably to have known that Mr. Watson's donation constituted the proceeds of unlawful activities. Additionally, it cannot be said that the president ought reasonably to have known that Mr. Watson made, and there is no evidence to suggest this, a tainted donation to his campaign and then failed to obtain information to confirm or disprove the fact. Clearly, the public protector had no foundation in fact and in law to arrive at her finding that the president had involved himself in illegal activities sufficient to evoke a suspicion of money laundering. In addition, the public protector based her finding on legislation that had nothing to do with the offense of money laundering. The conclusion is inescapable that in dealing with this issue, the public protector completely failed to properly analyze and understand the facts and evidence at her disposal. She also showed a complete lack of basic knowledge of the law and its application. She clearly did not acquaint herself with the relevant law that actually defines and establishes the offense of money laundering before making serious, unsubstantiated findings of money laundering against a duly elected head of state. Had she been diligent, she would not have arrived at the conclusion she did. In fact, the FIC had told the public protector in April 2019 at a meeting with her that its investigation could find no indication of money laundering, as they could not establish whether any of the monies deposited to the CR17 campaign accounts constituted the proceeds of crime. The FIC told the public protector that the payment from Mr. Watson came from sources that appeared to be lawful. Of course, even if Mr. Watson's sources of funding were suspect, and there was no evidence to this before the public protector, the suspicion of money laundering might fall on Mr. Watson, but he was not the subject of the public protector's investigation. Quite how the public protector thought that the president might have harbored the requisite knowledge to constitute this crucial element of the offense on the evidence before her is unfathomable. The only real clue to the public protector's reasoning on the money laundering issue comes from the following passage. I quote, "A criminal may attempt to integrate the funds she received from corrupt activity, such as a bribe or kickback, into a financial system by channeling the funds through complex financial transactions during which she may involve several entities as conduits, financial institutions as a means to disguise the corrupt source of funds as well as the ultimate beneficial owner of the proceeds of unlawful activity." Close quotation. This passage formed a direct link to her conclusion that there was suspicion of money laundering. In her reasoning, the public protector assumed that the monies donated to the CR17 campaign constituted bribes or kickbacks, presumably for political favors. It's not clear who the public protector suspected was the criminal receiving them. However, as she was investigating the president, one must assume that he was the suspect. The allegation at the heart of her reasoning is extremely serious. It implies that the president orchestrated the entire CR17 campaign and used it as a vehicle for laundering the bribes he received from donors in return for political favors. This kind of allegation, even if implied and not expressed, ought not to be made without strong supporting evidence. We need to emphasize once again that in this case, the public protector had no evidence before her to substantiate this very serious allegation. The role of the public protector is to, open quotation mark, inspire confidence that all is well in public life, close quotation. Of course, this does not mean that she must suppress evidence or curtail her investigations inappropriately to protect public figures. But she is required to approach each case with an open mind. On the money laundering issue, the public protector displayed anything but an open mind. She made serious findings based on unfounded assumptions. She paid no regard to the statute that establishes the very offense in which she implied the president is suspected to have been involved. We find that her findings on the money laundering issue were not only irrational, but indeed reckless. Consequently, they fall to be reviewed and set aside.
The next heading is the audio alteram partem. The President contends that the public protector failed to afford him a hearing in respect of the remedial action she included in her report. It is common cause that the public protector afforded the President a number of opportunities to make representations to her, and that he took advantage of those opportunities. However, it is also common cause that she did not give him any forewarning about the remedial action that she was contemplating. She did not include the remedial action in her Section 7, Sub 9 notice to the President. In his response to that notice, the President specifically requested that he be given an opportunity to address her on any remedial action she was contemplating. The public protector elected instead to simply include the remedial action in her report without affording him that opportunity. Section 7, Sub 9A of the Public Protector Act obliges the public protector to afford a hearing to persons implicated in any investigation. The public protector's stance is that Section 7, Sub 9A does not oblige her to give a person being investigated a hearing on her contemplated remedial action. She says that in her notice to the President, she forewarned him that the remedial action could be a referral of the matter to the relevant authorities. She contends that this was sufficient compliance with her obligations under the audi alteram partem principle. Section 7, sub 9a does not expressly require the public protector to include her contemplated remedial action in the notice to a party under investigation. However, that does not mean that the public protector may not be obliged to do so. The facts may be such that in order to constitute compliance with a person's constitutional right to just administrative action, she should afford them this opportunity. In this case, the remedial action directed by the public protector has potentially serious implications for the President. The Speaker is directed to demand that he disclose all donations made to the CR17 campaign. This is information which, on the evidence before the public protector, is not known to the President. He accordingly runs the risk of falling foul of a directive from the Speaker that he discloses information about funds he never personally received, but which was raised and spent by the CR17 campaign to advance his campaign to become President of the ANC. However, even more serious for the President is the remedial action relating to the money laundering issue. In terms of this remedial action, the NDPP is directed to conduct further investigations into the prima facie evidence of money laundering. The effect of this direction is that the President potentially would be a criminal suspect for an offense that carries the possibility of a 30-year period of imprisonment. Thus, the remedial action she proposed was at least as important, if not even more so, as a finding of a suspicion of money laundering. Given these serious implications of the remedial action, the President's right to just administrative action placed an obligation on the public protector to be forewarned of them and to be given an opportunity to make representations. She failed to comply with this obligation. In the circumstances, the remedial action she included in her report falls to be reviewed and set aside. The next heading is the review of the remedial action. The Speaker and the NDPP are the main proponents of the review of the remedial action directed by the public protector in a report. The President supports the review. These parties contend that the remedial action and monitoring measures are inappropriate, in some instances ineffective, and constitute a usurpation of the constitutional discretionary powers of the Speaker and the NDPP. The public protector is empowered under Section 182, sub 1 of the Constitution to take appropriate remedial action. The courts have fleshed out that this power means and entails. The courts have fleshed out what this power means and entails. Remedial action that is binding cannot be ignored. However, it is open to judicial scrutiny. The public protector has the power to direct or instruct members of the executive to exercise powers entrusted to them under the Constitution where that is required to remedy the harm in question. However, the public protector is an organ of state and must abide by the constitutional principle of separation of powers. She must give due deference to the expertise within other organs of state. We deal now with the remedial measures directed to the Speaker. Cardinal to the power of the public protector to determine an appropriate remedy is that the remedy should be effective. The Speaker challenges two of the public protector's remedial measures on the basis that they lack this essential quality. The public protector directed the Speaker to refer the President's violation to the Joint Committee on Ethics and Members' Interests for consideration in terms of the provisions of paragraph 10 of the Code of Ethical Conduct and Disclosure of Members' Interests for members of the Assembly and Permanent Council members, that is, the Parliamentary Code. She also directed the Speaker to demand publication of all donations received in the Members' Register of Interests. The Speaker points out that the President is no longer a member of the National Assembly. He ceased being a member when he was elected as President. The Joint Committee has no competence to consider complaints against former members, save for limited circumstances which do not apply here. Similarly, The register of disclosable interest applies to members of the National Assembly. The Speaker submits that these two remedial directives are ineffective as they fall outside her area of competence. She has no power to refer a complaint to the Joint Committee or to require registration of interest in respect of ex-members of the National Assembly. The Speaker's submissions find support in paragraph 3.1 of the Code. As the President is no longer a member of Parliament, the Code thus does not apply to him. The Code has limited application to former members. The Public Protector did not engage with the problem raised by the Speaker in this regard. In oral argument, we sought to determine whether the Public Protector accepted that the Joint Committee did not have the requisite competence or whether she disputed this. Counsel for the Public Protector responded that this was not for the Public Protector to decide. Surely, if the Joint Committee does not have competence, this is something with which the Public Protector must engage. She has an interest in ensuring that her remedial measures are effective, and this is an issue that should have concerned her. She cannot suggest it is up to the Joint Committee to decide whether it is competent to consider the complaint. We find this attitude on the part of the Public Protector to be puzzling. It is plain that the Joint Committee does not have the competence to consider the complaint that the Public Protector has directed the Speaker to refer to it. Nor does the Speaker have competence to demand that the President, who is no longer a member of the National Assembly, should disclose the CR17 donations in the register of members' interests. The remedies fashioned by the Public Protector are thus ineffective and inappropriate. They also constitute an unlawful interference with the Speaker's constitutional role to determine what measures are most appropriate to deal with conduct that is alleged to breach the rules or codes applicable to the National Assembly. The appropriate action is for this court to set aside the remedial action imposed by the Public Protector. The monitoring mechanisms related to the measures must follow the same fate. The remedial action in paragraph 8.2 of the report directs the Speaker, and I quote, "Within 30 days of receipt of this report, consider within her discretion for deliberation by members of Parliament in terms of the rules of the National Assembly, issues relating to my observations under paragraph 6.1 to 6.6 of this report for possible review and amendment thereof." I close quote. The Public Protector's observations related to the view expressed by her in a report about the conduct of members in not properly considering questions posed to them before answering, and the lack of clarity in the rules of the National Assembly as to whether members may subsequently clarify an answer by providing a written response. This was not foreshadowed in either complaint, and it is remarkable that the Public Protector actually ventured this far. The fact of the matter is that the Speaker received the President's subsequent written clarification without demur. That was the end of the matter. We failed to grasp what just cause the Public Protector had to deal with this aspect, especially as the Speaker had no issues with it. In our view, the direction to the Speaker lacks clarity. But if it is intended to be a directive to the Speaker to exercise his discretion, then it is difficult to understand why such a direction is necessary in this case. Discretionary powers are generally left to the holder of the power to exercise. While there may be instances where the Public Protector is lawfully entitled to encroach on a discretionary power and to direct that it should be exercised and in what fashion, such a remedial measure must be necessary and appropriate to remedy the prejudice associated with the complaint. Clearly, in our view, this was an unwarranted encroachment on the Speaker's discretionary power by the Public Protector, and it is similarly reviewed and set aside. I now deal with the remedial measures directed at the NDPP. The Public Protector directed the NDPP, and I quote, "Within 30 days of receipt of this report, to take note of the observations contained in paragraph 7.3.1, as well as the recommendations contained in paragraph 7.3.3 of this report, and in line with section 6, subsection 4C, Roman figure 1, of the Public Protector Act, conduct further investigation into the prima facie evidence of money laundering as uncovered during my investigation and deal with it accordingly. I close quote. The Public Protector directed the NDPP to submit to her, and I quote, for approval of the Public Protector, close quote, an implementation plan indicating how the remedial action will be implemented. Section 6, subsection 4C, Roman figure 1 of the Public Protector Act makes specific provision for what the Public Protector may do if she forms the opinion as a result of her investigations that there are facts disclosing the commission of an offense. In that instance, she may bring the matter to the notice of the relevant authority charged with prosecutions. The Constitution gives the National Prosecuting Authority, which is headed by the NDPP, the power to institute criminal proceedings and to carry out necessary functions incidental to this. Under Section 32, Sub 1B of the National Prosecution Authority Act, no organ of state may improperly interfere with, hinder, or obstruct the NPA in the exercise of its powers, duties, and functions. Thus, the NPA enjoys prosecutorial independence. The remedial action and monitoring measures directed at the NDPP go much further than is permitted by the Public Protector's powers. Although she refers to her observations and recommendations, it is plain that the Public Protector was doing more than simply bringing the matter to the attention of the NDPP. Her remedial measure includes a direction to conduct further investigations. Further, the monitoring measure directs the NDPP to submit a plan which will be subject to the Public Protector's approval. Understandably, the NDPP was concerned about the Public Protector's directions to her. She wrote to the Public Protector for clarity. She asked the Public Protector if the remedial measure was simply intended to be a referral to the NDPP under Section 6, subsection 4C, Roman figure 1, or whether the Public Protector expected the NDPP to do more to comply with the direction. The NDPP hoped that the remedial action in the report might simply be a case of bad drafting and not an attempt to encroach upon the NDPP's independence by directing her to undertake an investigation. The response from the Public Protector's Office is surprising. It noted the NDPP's letter with regret. It made it perfectly clear that it expected the NDPP to comply with the direction and to submit an implementation plan to the Public Protector. Further, the letter implied that the NDPP was aligning herself with and being influenced by the President in seeking to question the Public Protector under the guise that the remedial action were lacking in clarity. Having obtained no assistance in trying to settle the matter by engaging with the Public Protector, the NDPP had no option but to approach the court to seek to review the remedial measures directed at her. Strangely, in her answering affidavit, the Public Protector suggested that, and I quote, furthermore, the consistent attacks against the remedial action are equally spurious and ill-conceived. They fail to recognize that such remedial actions are couched in a manner that leaves the discretion with the authorities such as the NDPP to perform their functions. If these institutions believe they should do nothing, they are entitled to do so, if such discretion is exercised lawfully and for a legitimate purpose. I close quote. This is a surprising suggestion from the Public Protector. As we pointed out earlier, the NDPP could not lawfully simply ignore the Public Protector's remedial action directed at her. The remedial action was not in the form of a mere recommendation. On the contrary, it required the NDPP to act, and furthermore, it required her not only to submit an implementation plan on her action to the Public Protector, but also to obtain the Public Protector's approval of the plan. The Public Protector has no power to direct the NDPP when or how to carry out her functions. nor does she have powers to monitor the NDPP's conduct. That would be to undermine the very essence of prosecutorial independence. The Public Protector Act makes this clear by limiting the options open to the Public Protector. If she uncovers evidence of a possible crime, she may bring the matter to the attention of the prosecuting authority. We must also turn to a submission advanced by both counsel appearing for the Public Protector and the EFF. That submission was advanced in relation to the objections by the Speaker and the NDPP regarding the competence of the Public Protector to issue remedial action against anyone should she be so minded, and to do so in a manner that impinges on their ordinary discretionary powers. Once again, this submission is reliant on the Zuma case discussed earlier. We were urged to follow that decision, as its import was that this court sanctioned remedial action issued by the then Public Protector against former President Zuma. That remedial action curtailed his discretionary powers to appoint the chairperson of a commission of inquiry on the basis that his private interests may have affected how he discharged the powers of his office. A number of important considerations seem to have been ignored by the proponents of this submission. The Public Protector report considered in the Zuma case was dubbed the state of capture report for a reason. The facts relied on by the then Public Protector in crafting the remedial action regarding the appointment of the chairperson of the commission were of allegations of corruption involving the then president and members of his family in state affairs and state institutions. As we explained earlier, what was at issue in the report in the Zuma case was alleged corruption of the then president in state affairs. We need say no more, as the facts in that case speak for themselves. We pause to simply point out that in the case before us, the complaints said nothing about alleged corruption of the president in state affairs. The complaints focus on a 500,000 rand donation by Mr. Watson to a private party political election campaign supporting the president's candidature for the position of president of the ANC. We have deliberately referred to portions of the Zuma case to dispel the submission that that case is good authority to uphold the remedial action issued to the Speaker and the NDPP in the case before us. This is a misconstrued submission. On the facts before us, the remedial action issued by the Public Protector is incompetent for reasons we need not repeat here. Furthermore, as we point out above, the facts are very different, and there are no allegations of corruption leveled against the President in state affairs in the complaints investigated by the Public Protector. The Constitutional Court in the EFF versus Speaker case decreed that remedial action is situational and context-specific. The context in our case is that the Public Protector has issued illegitimate findings from which no competent remedial action can follow. The Public Protector exceeded the lawful limits of her powers in the remedial action and monitoring measures she directed at the NDPP. She was entitled to bring what she considered to be a prima facie evidence of money laundering to the attention of the NDPP, but she could not expect the NDPP to investigate on her direction or to obtain her approval for the implementation plan. This was the plain import of her directions to the NDPP. Consequently, the remedial action and monitoring measures must be set aside. We are constrained to find that the Public Protector's issuing of the remedial action to the NDPP, coupled with her insistence when the NDPP queried her that she expected the NDPP to carry out a directive, displays, in our view, a complete lack of understanding on her part of the limits of her powers as provided in Section 6, subsection 4C, Roman figure 1 of the Public Protector Act in relation to matters falling under the NPA. We also find that she displayed a clear failure to grasp the meaning of the concept of prosecutorial independence decreed by Section 32, sub 1B of the NPA Act. The Public Protector Act and the NPA Act are clear that she has no power to direct the NDPP to investigate any criminal offense and how to go about doing this. I turn now to the Ramaphosa's application. Ramaphosa brings a constitutional challenge to the Executive Code. It is a conditional challenge as appears from the terms of the relief it seeks, and I quote, "In the event that the Executive Ethics Code is held not to require the disclosure of donations made to campaigns for positions within political parties, 1, it is declared that the code is unconstitutional, unlawful, and invalid to this extent, and 2, the declaration of invalidity shall have no retrospective effect and shall be suspended for a period of 12 months to allow for the defect to be remedied." I close quotes. The constitutional provisions that Ramaphosa relies on to mount its constitutional challenge are Section 7(2), 19, 32(1), and 96 of the Constitution. Its case may be summarized as follows. Transparency is critical to the functioning of the democratic process. Access to information is an important tool in achieving transparency. Access to information is indispensable to the right to vote and to make truly free political choices. Further constitutional considerations apply with respect to Section 96 of the Constitution and the Ethics Act. Section 96 makes it plain that members of Cabinet and Deputy Ministers may not act in any way that exposes them to a risk of a conflict between their official responsibilities and their private interests. They may also not use their position to enrich themselves or to improperly benefit. Corruption may result from a breach of these constitutional ethical precepts. The state has a duty to take steps to combat corruption. Access to information is a key corruption-fighting tool. Thus, the state must ensure that the Executive Code serves as a shield against potentially corrupt acts by requiring disclosure. Politicians receive a tangible benefit from their political campaigns, and this leads to a risk of patronage and corruption. Secrecy enables corruption in that it conduces more to a disposition by politicians that is favorable towards those who funded them privately once they are elected into public office. Consequently, if this court finds that the Executive Code does not require disclosure of donations made to campaigns for positions within political parties, this means it is unconstitutional and invalid to the extent that it breaches Section 1, 7 subsection 2, 19, 32, and 96 of the Constitution, and the Ethics Act, particularly Section 2, sub 2A and B. There is no doubt that Ramaphosa's case is founded on issues that are critical to our democracy and the constitutional project. It is unthinkable that anyone concerned with the proper functioning of our constitutional democracy would disagree with the broad principles outlined in their submissions. We certainly do not. We also agree that access to information is a key tool in combating corruption. The importance of the right of access to information in the context of the right to vote was dealt with fully by the Constitutional Court in My Vote Counts 2. It is so that that case was particularly concerned with the right to vote in national elections under Section 19, subsection 2 of the Constitution. However, Section 19, subsection 1 gives everyone the right to participate in the activities of political parties and to campaign for a political cause. The right of access to information is undoubtedly of importance to the exercise of those rights too. Counsel for Ramaphosa made a compelling case highlighting why these principles are so important and why access to information is so key to the ability to exercise one's broad political rights. He also made a compelling case for the link between information about funding within the political context and rooting out corruption. Compelling as the arguments may have been, however, we are not persuaded that the constitutional challenge has been raised properly before us. We say this for the following reasons. The effect of our finding is that the Code does not require disclosure of indirect benefits to members of the executive in the nature of party political campaign donations. It is this conclusion that Amabungane submits provides a basis for us to consider and decide their constitutional challenge to the code. In order to grant Amabungane's relief, we must find that the code is constitutionally deficient on the basis identified by Amabungane. There are some problems with Amabungane's challenge in this regard. The challenge cannot rest on Section 96 of the Constitution alone. If it did, then Amabungane would face the same subsidiarity difficulty that the applicant faced in My Vote Counts NPC versus Speaker of the National Assembly and others. That is the My Vote Counts 1 case. In that case, the court rejected a constitutional challenge based directly on Section 34 of the Constitution. It found that the challenge should have been mounted against the Promotion of Access to Information Act. Amabungane attempts to avoid this problem by directing their challenge to the Executive Code. We are not persuaded that this gets Amabungane out of the woods. The Executive Code follows the Ethics Act in that it requires disclosure of financial interests. As we have already pointed out, the indirect benefit of a well-funded campaign for a candidate's party political power base is not a financial interest as envisaged under the Act. Nowhere in Section 2 can one find even remotely that indirect and intangible benefits gained through internal political party donations are contemplated or meant. The code is more specific in that it lists the types of financial interests that must be disclosed. However, it is aligned to the Ethics Act in that these interests are restricted to being financial in nature. The code cannot require greater disclosure than that required under the Ethics Act. If this is too narrow a meaning, such that it amounts to an unconstitutionality, as Amabungane suggests, then in our view, the constitutional challenge should be directed at the Ethics Act. A challenge to the code without a challenge to the Act is not permissible. Indeed, even if the Executive Code was amended to make disclosure of party political campaign funding a requirement for members of the Executive, this would not meet the purpose of the guarantee of the right of access to information. It would mean that only existing members of the Executive would have to be transparent about their donors. Those politicians who are vying for positions in their party who are not covered by the code would remain as intransparent as possible. The right of access to information for purposes of enjoyment of one's Section 19 sub 1 right require more than selective transparency. There is a further difficulty with Amabungane's challenge. The essence of the Order 86 is that the code must be amended so as to require that the disclosure of donations made to campaigns for positions within political parties is made by members of the Executive covered by the Executive Code. This would require us to enter into the Executive and Parliament's constitutional terrain by prescribing the ambit of the duty to disclose. That is something that falls to them to determine. It is not for the court to be prescriptive. To do so would undermine the separation of powers. To paraphrase with contextual changes what the Constitutional Court said in the My Vote Counts 1 case, it may well be that it would be ideal to require members of the Executive to make disclosure of donations made to campaigns for positions within political parties. Who knows? But that is not the issue. It is for the Executive, after consultation with Parliament, to decide. In fact, there may be good reason for them not to follow Amabungane's path of action. It is equally arguable that members of the Executive should be kept in the dark about who donates to their campaigns in order to avoid the risk of conflict and patronage. To require disclosure in the manner sought by Amabungane would force them to know who has supported them. This could provide its own risks down the line. These are all issues that fall to be discussed and debated by other organs of state and not the court. The ultimate result is that we find that the constitutional challenge must be dismissed. We wish to emphasize that we do not dismiss the application on the merits. We make no finding as to whether the code is constitutional or not. That is an argument for another day. As we have already indicated, the underlying issues raised by Mkhwebane are critical to our democracy. There are sound reasons for why the public should have easy access to funding information, whether in respect of individual politicians or political parties. However, this was not the case in which the constitutional implications of these issues could be fully ventilated. I now deal with the issue of costs. In respect of some of the parties, there is no issue as to the question of costs. The FIC did not seek an order as to costs, and nor did the information regulator. Mkhwebane submitted that the principles laid down in the BioWatch judgment should be applied to them, and that they should not be mulcted in costs in the event of them being unsuccessful. We agree with Mkhwebane's submissions in this regard. The EFF also sought an application of the BioWatch principles to it. Although the EFF sided with the public protector in contending that the grounds of review had no merit, the basic principle should still apply to the EFF. It was unsuccessful. However, it sought to intervene in what was a constitutional matter and should not be mulcted in costs, even though its support for the public protector was unsuccessful. As to the public protector, there is no question that she should be ordered to pay the costs of the President, the Speaker, and the NDPP for her unsuccessful opposition to their review applications. The only question is the scale of the costs that she should be ordered to pay. The President submits that she should be ordered to pay costs on the punitive scale of attorney and client. He does not suggest that the conduct of the public protector warrants her being ordered to pay costs in her personal capacity. Counsel for the President submitted that the conduct of the public protector in this case shows a reckless determination to make an adverse finding against the President. They point to what they submitted was her egregious misreading of the Executive Code and her baseless and very serious conclusion that there was prima facie evidence of a suspicion of money laundering. They submit that her investigations showed a determination to malign the President by making very serious findings against him without engaging meaningfully with the evidence before her and the applicable law. The principles applicable to the court's discretion to order costs on a punitive scale, as opposed to on a party and party scale, are usefully collected and referred to in the Constitutional Court judgment in the Public Protector versus South African Reserve Bank case. Costs are a discretionary matter for the court concerned. Such costs are warranted when it would be unfair to expect a party to bear any of the costs occasioned by the litigation. The question must be answered with reference to what would be just and equitable in the circumstances of a particular case. The general principle is that an attorney and client scale is awarded when a court wishes to mark its disapproval of the conduct of a litigant. Courts have awarded this scale of costs to mark their disapproval of dishonest or malafides conduct, vexatious conduct, conduct that amounts to an abuse of the process of court, or conduct that is extraordinary and worthy of a court's rebuke. As costs lie at the discretion of the court, this is not a closed list. Public officials attract special consideration when it comes to punitive cost orders, and they may even order to pay costs out of their own pockets. In the Public Protector versus South African Reserve Bank case, the Constitutional Court said the following, and I quote, "A higher duty is imposed on public litigants as the Constitution's principal agents to respect the law, to fulfill procedural requirements, and to tread respectfully when dealing with rights. The Public Protector is therefore enjoined by the Constitution to observe the highest standards of conduct in litigation." And I quote further, "There is no merit in the Public Protector's contention that the independence of her office and proper performance of her functions demand that she should be exempted from the threat of being mulcted with adverse personal cost orders. On the contrary, personal cost orders constitute an essential constitutionally infused mechanism to ensure that the public protector acts in good faith and in accordance with the law and the Constitution. I close quotes. While the latter excerpt refers specifically to personal cost orders, the underlying principle is applicable also to attendant-client costs orders against the public protector. It underlines that the public protector is carrying out a constitutional duty and that the Constitution demands that she is scrupulous in using her powers in accordance with her constitutional mandate. We have discussed the public protector's broad powers and the particular mandate given to her under the Constitution. Her broad powers come with important obligations. In using them, she must act independently, impartially, and she must approach each investigation with an open mind. It is not surprising that given the weight of the constitutional burden she carries and the breadth of her powers, she is required to be a highly skilled professional in a relevant field of expertise. She must be expected to understand and correctly apply legal prescripts that may be relevant to investigations. She should consider all the evidence before her and weigh it appropriately and fairly before making an adverse finding. She should be conscious of the impact that an adverse conclusion may have on the rights of those she is investigating. She should not hesitate to make adverse findings when the evidence reasonably and rationally supports such a finding. Equally, however, she should not rush to conclusions and should tread carefully before making findings that may have serious implications for people within the scope of her investigations. Unless the public protector conducts herself in this manner, she runs the risk of undermining the very reason for the existence of her office. If she strays from this path, she will lose the confidence of the citizens for whom she has been appointed protector. For these reasons, it is critical that, where appropriate, courts should show their displeasure should the public protector fail to meet her constitutional mandate. It is a duty imposed on the courts by the Constitution itself. We earlier concluded that the public protector acted not only irrationally, but also recklessly in reaching her conclusion that there was evidence supporting a prima facie case of money laundering. We noted that this conclusion had potentially extremely serious consequences for the President. This is not a consequence peculiar to him because of the position that he holds. Anyone against whom such a finding is made would potentially find themselves under investigation for an extremely serious offense. However, the fact that it was the President is an added concern. When the head of state is implicated in money laundering, it immediately presents a threat to the well-being of the public at large. If the implication is well-founded, then this is a consequence with which the general public must come to terms. However, if it is reached irrationally and recklessly, it is another matter entirely. What makes the public protector's conduct in this regard worse is that despite being requested to give the President an opportunity to respond to the remedial action she had in mind, she refused to do so. The President was not given sight of her remedial action directing the NDPP to investigate money laundering. It is unclear why the public protector failed to comply with one of the most fundamental principles of natural justice by declining the President's request to be permitted to make representations on the remedial action. It would not have unduly slowed down her investigation, which seems to have been conducted at relative speed. The public protector ought to have understood the importance of not making findings that will have such serious implications without affording a proper hearing to the persons affected. At the very least, she failed to show appreciation for an elementary principle of due legal process. Of similar concern is a confusion over the proper version of the Executive Code. She has not explained how she committed this error. Her conduct in this regard goes further than simply having reference to two different versions of the code. The legal test for a violation of the code by misleading the National Assembly was fundamentally different in the two versions. Instead of appreciating the difference between the willful misleading of the National Assembly and the inadvertent misleading of it, she asserted that if she had made an error at all, it was an immaterial error of form over substance. This submission shows a flawed conceptual grasp of the issues with which she was dealing. Like any official required to make pronouncement to the public protector must surely strive to be as clear as possible in her findings. Her reasoning on the disclosure issue was muddled and difficult to understand. It failed to explain to the public why she had found that the president of the country had willfully breached the duty of transparency established by the code. Indeed, her conclusion inexplicably found that at the same time, the president had also inadvertently misled Parliament, sowing further confusion. As counsel for the president pointed out, although the public protector received full representations from the president, she did not engage meaningfully with them. She did not deal with the explanations as to how the CR17 campaign was structured and how it functioned. She did not engage with the explanations that the transfers between the various accounts were aligned with the very structure of the CR17 campaign itself. Instead, and despite this evidence before her, she persisted with her thesis that there were reasons to suspect that the CR17 campaign was involved in state capture of some sort, and that a prima facie case of a suspicion of money laundering had been established. She recklessly ignored the evidence at her disposal. She pointed to the opposite conclusion. In doing so, she breached her duty to approach every investigation in an open-minded fashion. Finally, we are concerned by her attitude to the Speaker and the NDPP. As we have already described in a letter in response to the NDPP, the public protector implied that the NDPP was being unduly influenced to back the president's case. Such an implication is completely unfounded, particularly in circumstances where we have found that the NDPP was entirely correct to seek clarity and subsequently a review of the public protector's directive. Her attitude to the Speaker is equally concerning. In her answering affidavit in response to the Speaker's review, the public protector says that the Speaker's review is tantamount to demonstrating support for the President and is a failure to stand on the side of accountability. These are reckless statements to make against another organ of state and deserve the opprobrium of the court. The totality of the public protector's conduct highlighted above warrants an adverse cost order against her. In our view, an order that she be directed to pay the President's costs on an attorney and client scale is warranted. Our conclusion order is therefore as follows. As is apparent from our judgment, the public protector acted unlawfully in exercising her powers in the manner that she did in this matter. We have found, for the detailed reasons given above, that her investigation into the CR17 campaign donations fell outside her field of competence. Further, that her report and the findings and remedial action contained in it were invalid on several grounds. It follows that they cannot stand and must be set aside. In the result, the review of the President, the Speaker, and the NDPP succeed. We make an order in the following terms. 1. The public protector's decision to investigate and report on the CR17 election campaign for the African National Congress leadership, elected in December 2017, is reviewed, declared invalid, and set aside. The public protector's report number 37 of 2019/20 of 19 July 2019, including the findings and remedial orders in paragraph 7.1, 7.2, 7.3, 8.1.1, 8.1.3, 8.2.1, 9.1, 9.3, and 9.4 is reviewed, declared invalid, and set aside. The public protector is ordered to pay the costs of the first applicant on the punitive scale as between attorney and client, including the cost of two counsel. The public protector is ordered to pay the cost of the second applicant and the third respondent on the party and party scale, including the costs of two counsel. No order as to cost is made in respect of the fourth, fifth, and sixth respondents and the amicus curiae.
I agree.
I agree.
We hand down our judgment. Court adjourns.